misbehavior. Because the framers of the Constitution thought it desirable to outline, certain everyday, words and to assign meanings in the Constitution in Article 295. But with regard to stated misbehavior, the framers, didn't say anything and let it ajar so that it will depend upon interpretation, and judges, are also, ordinary mortals. When you give them the chance to interpret. So you see in the Frank Ejechum, and AGN Bright Akwete case that, the retired Chief Justice, Professor Dateba, went to lengths. But still, if you read, the judgment, and, luckily, Bebu, has walked us through pages 766 and 767 and all that. You see that even after outlining examples, our respected, Justice Dateba still left it open, meaning that the categories are not yet closed. So day in, day out, other, things could come in which will qualify as stated misbehavior. So that's the second, the absence of any, definition to guide the court. The third, self-induced, was the nomination and subsequent appointment of Torkornoo, out of 10 by the former president, which, was severely criticized, but the former president, didn't heed, any call to take a second look at that. For me, that was a catalyst,
There were other senior persons?
Sure.
Than him.
Taken out of 10. Then the fourth circumstance of accident, the fetish that we are making of our precedents. So the Frank Ejechum stood guard over any remedial measure, favorable measure, for Torkornoo. Stood guard because the Frank Ejechum thing had interpreted Article 146 holistically in accordance with the canons of interpretation, that in interpreting or construing a provision in the statute, you do so, so as to make a consistent meaning by looking at the entire. So you don't merely look at Article 146, 6 to 11 in relation to the removal of the Chief Justice, but you also go backward to Article 146, Clause 1, which will provide guidance on stated misbehavior. This is, what has caught up, with this whole saga of total loss. If in Frank Ejechum, the Supreme Court, had said, look, we notice first and foremost that a Chief Justice can only be a Chief Justice, if he has served a certain number and being appointed from among, the justices of the Supreme Court. The question is, what if the Chief Justice is not coming from the bench? Would Article 146(1) apply to such a person? Because the person, wouldn't in the first place have been a justice of the Superior Court upon elevation, to the high office of, Chief Justice. So the Supreme Court in Frank Ejechum, I think missed the point when they put the two together and said, by parity of reasoning, since, you can only be a Chief Justice, if you are a justice of the Superior Court, and therefore whatever affects, your position or status of Chief Justice, must relate back to your status as a justice of the Supreme Court. This is where the harm is. It's a misconception because Article 146, Clause 9 refers to in each case. So the Supreme Court should have segregated that you may be a justice of, the Supreme Court. If we are looking at your exercise as a CJ, yes, Article 146(1) says stated misbehavior, of a justice of the Supreme Court. Therefore, we would, divide into two, limit ourselves to justices of the Supreme Court and then limit ourselves to the CJ who is being removed. If they had, told that line, we wouldn't have a situation where, it relates back
to the instance.
When the Constitution says there shall be no retroactive legislation, but you are interpreting a provision of the Constitution retroactively. I don't think, their lordships were right, insofar as they did that. And that is, what has affected former Chief Justice Torkornoo. Then the fifth, self-induced. Why ask a daughter to be a contractor in respect of some services in your office? She brought it, upon
decorating
herself.
An office.
Yes, she brought it upon
and the
herself.
furniture and all of that.
Yes. The other one, my good friend Kofi Bento, was struggling, to align. You see, it is an audit issue, yes. But who is the head of the judiciary? The Chief Justice. Article 125, Clause 4 is clear. The Chief Justice shall be the head. So the buck stops on her desk. So whether an accountant or the auditor or whatever, any person, it is the Chief Justice. And she could not claim ignorance that being the head, the buck stops on her desk. Being the head, the buck stops on her desk. So trying to claim ignorance that, well, as my good friend will put the meeting baby, and now they are there no buy, and I mean, so me sign. I mean, it will lie in the mouth, to say so. So she must have known, the consequences, of signing. But after all, who approves and who disapproves? This is the Chief Justice. But the most serious of the stated misbehavior, from my point of view, was the attempt on her part to use a certain provision of the Civil Service Act to recommend the appointment of, some 5 persons as justices. That constituted judicial misconduct.
So it's serious, more than the misappropriation of this.
Judicial misconduct. See, if you look at the Judicial Service Act 2020, Act 1057, as chairperson of the Judicial Council, she has the following powers. I'm reading Section 7. That's stated misbehavior.
It is.
Stated misbehavior. So, members of the service and vacancy. Where there is a vacancy, that's Section 7, I'm quoting. Where there's a vacancy, A, under paragraph H, under paragraph B of subsection 3, or subsection 4, or subsection 2, of section 9, or B, as a result of a declaration under subsection 6, or C, by reason of the death of a member, the Chief Justice shall notify the President of the vacancy, and the President shall, in respect of a person who is appointed by the President under paragraph N of section 5, appoint a person to fill the vacancy. Uncle. She was trying to lift this particular provision, and under this, wrote a letter to the President, listing 5 persons. And when I looked at it, and Article 144, I felt, it amounted to judicial dishonesty. And for that, I was on air, that, she should be reprimanded. And on one of your shows, I did say that it could cost her her job for trying to be deceitful. For me, I mean, that could have, and Kwaku, read
In
into it and quickly.
That's what was coming to, because this particular one was captured in Professor Stephen Kokwa's
Sure.
petition,
Sure.
which was thrown out by the former president, Nana Addo Akufo-Addo, that it didn't constitute any grounds whatsoever for any misconduct. But this same concern has found favor in the sight of another
it's very
committee.
serious,
That
very serious. It meant that she was trying to procure the elevation of those 5 justices by fraud. And fraud vitiates everything. As a Chief Justice, she had, subscribed to the oath, to act in accordance with the Constitution. Why try to use, a provision not in the Constitution as a basis for appointment of, persons to the Supreme Court? I mean, if there was any stated misbehavior, I would just rely on that and say that, that was sufficient. I will not bother. But because, Kofi says that the 337 or this thing, I want to, tell Kofi, you see, if you admit to some infraction, and so by way they say, refund it, the high office of Chief Justice, it is not kitikiti. And the Martin, refers to our good friend, Yaya Santua. Former Chief Justice Sophia Akufu would always, usefully remind everyone, especially, law students going to take their entrance exam, that when you take the exam and the pass mark is 50, and you had 49, 0.9, now, kase ka kitikiti in kaminya 50, and kitikiti in law doesn't exist. You either had a 50 or you didn't have a 50. So there's nothing like a kitikiti. Therefore, 337,000 will sound kitikiti and grating to the ear of civic-minded person. But the law is the law.